All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States and bless this honorable court. Please be seated.
Madam Clerk, if you'll call the case.
Case number SC0240454, Zynga Incorporated, the Gayla Mills. And in case number SC240455, Huuuge Incorporated, the Olivia. Arguing for the appellants, the Honorable John Nyman and the Honorable Aaron Ashcraft. And arguing for the appellee, the Honorable John Norris.
Is the appellant ready?
Thank you, Madam Chief Justice, and may it please the court. The cases on this morning's docket are unprecedented and raise serious concerns about the rule of law. These are two of what, by my count, are roughly 10 virtually identical lawsuits that recently have been filed against internet companies in Alabama State Court. The plaintiffs in each of these lawsuits are suing individual defendants, or company defendants, but different defendants in each case, over games that the plaintiffs readily admit that they have never played. The plaintiffs seek as damages money that was spent on these games not by the plaintiffs themselves, but rather by thousands of unnamed people across the state whom the plaintiffs do not purport to know. And all these other people, the people whose money is sought by the plaintiffs, the people who actually played these games, agreed to arbitrate with the defendants any disputes that arose over their play of these games or their expenditure of money thereon. So the questions teed up on appeal both concern whether the plaintiffs may, by virtue of this unprecedented way that they have pleaded their complaint under Section 81150B of the Alabama Code, evade certain critical rules of law. The Federal Arbitration Act on the one hand and Rule 23 and due process on the other. The answer to that question, Mr. Ashcraft and I would respectfully submit, ought to be an emphatic no. These complaints were no doubt unprecedented, but when the circuit court encountered them, existing principles of law required it to do two things. First, the Federal Arbitration Act required the circuit court to compel these plaintiffs to the same arbitration to which the players of these games whose money was being sought had agreed. But failing that, Rule 23 required the circuit court to dismiss these actions outright because the complaints purported to do two things that in tandem were in utter contravention of Rule 23. They purported to seek money on behalf of thousands of unnamed individuals, i.e., they were class actions, but they simultaneously disclaimed any intent or desire to do so pursuant to or under Rule 23. When the circuit court declined to dismiss this complaint as it was pleaded, it entered an order that had the substance and effect of a class certification, and the certified classes are currently set to proceed to discovery on the merits on a class-wide basis.
Mr. Nyman, I'm sympathetic to some of your due process arguments on the class action, alleged class action. I've never seen a case where a court holds that something is a class action where the plaintiff didn't plead it as a class action. Do you have a case for me?
Your Honor, I'd respectfully submit that the court has likely never seen a case in which a plaintiff pleaded a complaint in this way, seeking to transform a statutory cause of action into a case in which the plaintiff seeking damages for thousands of unnamed.
And I sympathize the due process issues for the defendants. the due process issues perhaps for these unnamed people, the question of standing, the question of joinder. There are all kinds of questions here. I'm just not sure it fits within the paradigm of a class action because they're the master of the complaint, and that's what they didn't say it was a class action.
The best precedents I can cite you to, Justice Cook, are the precedents of this court saying that in evaluating its own jurisdiction, this court evaluating its own jurisdiction, or in evaluating the meaning of a complaint, this court looks to substance rather than form. There are at least two precedents from this court, ironically enough, given the other issue presented in this case, involving review of orders that decline to compel arbitration. In those two cases, the trial court had not purported to deny a motion to compel arbitration. In both of these cases, the court looked to the substance and effect of the orders and said, regardless of what the trial court said it was doing, the substance and effect here was to deny the plaintiff or the defendant's motion to compel arbitration in those cases. Those precedents would be applicable here in a relatively new context that is created not by anything the defendants did, but rather by the way the plaintiffs pleaded their complaint. If this court goes down that road, it should hold that the order, when a plaintiff pleads a complaint in this way, seeking recovery on behalf of thousands of unnamed individuals, and disclaims Rule 23, then the plaintiff has, in substance and effect, pursued a class action. And if a trial court declines to dismiss a case that is pleaded in this way, that disclaims Rule 23, then it is issued an order that in substance and effect has certified a class. That said, I'm prepared to speak, and Mr. Ashcraft is prepared to speak to both of the issues that are presented to the court today, in whatever order and with whatever focus best aids the court's resolution of these appeals.
I'm just curious, if you were to prevail on your arbitration argument, would that predomit the second argument concerning the class action concerns?
Yes, Justice Shaw. And we are entitled to prevail on the arbitration issue. The critical line from the circuit court's order as to arbitration, a line that appears both in the Zynga and the Huuuge orders, is the following. It's on page 401 of the Zynga record. The court said, "It is undisputed that players of the game agree to this arbitration agreement and would be required to arbitrate their claims." Given that that proposition was not disputed by either the plaintiffs or the trial court, there are two independent and alternative reasons why the circuit court was required to compel arbitration here, whether on the one hand because of the delegation clause in this court's precedents in Reedstrom and Wiggins, or wholly in the alternative because of the stand in the shoes principle as enunciated by this court's 2002 decision in South Trust versus Ford. On the first of those grounds,
I want to direct your attention to your second ground because that intrigues me at least. The Starbucks case that got filed by the respondents, the appellees, it talked about the derivative claim doctrine. Is that what you're saying?
yes, I think that what the Florida courts refer to as the derivative claims doctrine looks much like what this court did in South Trust versus Ford. In other words, if the claim of the plaintiff in front of the court is effectively derived from a claim that would belong to a party to an arbitration agreement, then the plaintiff is deemed to have stepped into the shoes of that signatory for the purposes not only of pursuing the money that otherwise would have belonged to the signatory, but also for the purposes of any arbitration agreement that the signatory had entered into governing those claims and that money.
So, I mean, I'm trying to understand just doctrinally on your claim about derivative claims. Are you trying to shoehorn that in? I mean, we're talking about our law concerning arbitration, and we talk about non-signatories as applicable here. Potentially, we're talking about third-party beneficiaries, or or equitable estoppel. And I'm wondering, are you saying that this fits under equitable estoppel, or are you asking us to create some standalone additional exception for derivative claims, such as what you're arguing here?
Well, I think that it would be fair to phrase this as a kind of equitable estoppel argument. The one wrinkle I would add into the analysis is that equitable estoppel doctrine generally requires the court to look to the language of the arbitration agreement, and there may be some cases in which equitable estoppel would otherwise compel the non-signatory to arbitrate, but this court has said this particular arbitration agreement is too narrow and it can't cover non-signatories, so equitable estoppel doesn't apply. I do think that the stand in the shoes principle is broader than normal equitable estoppel, and the way that the court can discern that distinction is from South Trust versus Ford itself. In South Trust versus Ford, the arbitration provision at issue was narrower than the Zynga one here, in the sense that it was limited to, it required arbitration of claims between the signatory and the defendant in that case. This court said, despite that limitation, with respect to the claims brought by the administratrix in that state on behalf of the estate, that the administratrix was still bound, even though she had not signed the arbitration agreement, by the arbitration provision that the decedent had entered into. The reason why that makes sense, and the reason why there's a slight distinction from equitable estoppel, is because unlike an equitable estoppel case, the law and equitable principles deem the plaintiff in those circumstances to actually be, for all practical purposes, legally speaking, the original signatory to the arbitration provision. Now, to be clear, that's not the issues with the language of the arbitration provision don't even matter with respect to Zynga's case, because Zynga's arbitration provision is broad enough to cover claims involving non-signatories. But that is a distinction between normal equitable estoppel principles and the stand in the shoes principle that I discern from South Trust versus Ford.
Mr. Nyman, could I? Sorry.
This is really outside the scope, but do we need to determine whether this is a game of skill or a game of chance?
No, Justice Wise, I don't think that we're in that territory. This case doesn't look anything, in my view, like the decision you wrote for the court in Macon County Greyhound Park versus Hoffman. We're at the motion to dismiss stage here. Many facts need to be developed about that would be pertinent to that issue. The plaintiffs have conceded that, and the circuit court's order suggests that the existence of disputed facts remains. I don't think that's a threshold question that the courts need to decide given the presence of the arbitration provision. The arbitration provision would say that those issues need to be resolved by the arbitrator before any determination can be made about, for example, as you put it, whether this is a game of skill or a game of chance. That said, we anticipate prevailing on that issue in front of the arbitrator in no small part because these games look nothing like any game that has previously been declared illegal gambling in Alabama. We're talking about games where nothing is required to play, no money is required to continue playing, and ultimately, critically, no money can ever be paid out for these games. So at the very least, we're not in Macon County Greyhound Park territory where this court had to say over and over again, this particular game, electronic bingo, is clearly invalid and illegal, and the arbitration provision couldn't be enforced in that case.
Mr. Nyman, I have two questions, but following up on Justice Wise's question, that would be the same would be for the class action due process issues, would it not? Would those not be for the arbitrator?
That's correct. If this court determines that the circuit court should have compelled arbitration here, then one issue that would be put in front of the arbitrator would be whether these particular plaintiffs may proceed with claims on behalf of more than one person.
Mr. Nyman, your time is up, but please go ahead and answer Justice Shaw's other question.
I'd like to pose this to both counsel, just so that I understand. These plaintiffs are suing, as I understand it, basically an agency capacity, basically a representative capacity. They are given the right by statute to file a lawsuit on behalf of other individuals. So they personally have no damages. Am I correct on that?
Yes, I think that's a key component of the plaintiff's theory of the case. The reason why the plaintiffs need that to be the case is that they claim they're not bound by the arbitration provisions. If they had actually played these games, they would have entered into the same arbitration agreements that the players of the games had.
I guess my question kind of dovetails with Justice Mitchell's question concerning the derivative nature of the derivative theory that you've been talking about here. These plaintiffs really are not suing on behalf of themselves. They do not purport, am I correct, to receive anything from these lawsuits. They are suing on behalf of others. I know there's some language in the statute about how far that goes, but is this case any different than the cases where we have had executors and administrators and that kind of thing, having agreements with arbitration provisions of the deceased had entered into, and we have held that the executors or administrators are bound by those arbitration provisions?
Yeah, I think those cases are directly on point. The claim that is pursued by the plaintiffs here would not exist but for the expenditure of money on these games by the original players of the games. That means that the plaintiffs here and the family members whom they purport to represent both stand in the shoes of the original players for the purposes of the arbitration agreement, just like the administratrix stands in the shoes of the decedent for the purposes of any arbitration provision entered into by the deceased.
And right, I'd like counsel to address that as well, but this is basically a statutory procedural mechanism that allows these plaintiffs to be in court.
That's correct. I mean, we would contend that the plaintiffs haven't even done enough to show that they're entitled to go into court on behalf of someone else here in light of the U.S. Supreme Court's discussion of similar next friend type language. But nonetheless, at the end of the day, that is the way that plaintiffs are trying to assert these claims on behalf of someone else.
Thank you.
Thank you.
Thank you. Madam Clerk, if you will adjust the appellee's time for the time that Mr. Neiman went over.
Thank you, and may it please the court. I just want to add a few words. I'm prepared to discuss either the arbitration issue or the Rule 23 issue, whichever the court would prefer. If there's no preference, I would like to just point out that the plaintiff's theory, and they have presented this theory in their briefs consistently, where they maintain that none of these absent beneficiaries will be bound by this procedure. That's been their only answer to the challenge that, hey, you're violating the due process rights of these absent beneficiaries by bringing this claim on their behalf without their knowledge, without their notice, without their consent. They basically say it's all right because they're not going to be bound if we lose. And that creates huge due process concern for the defendants. The Phillips Petroleum v. Schutz case from the U.S. Supreme Court was presented as a defendant basically saying, hey, if you allow this to proceed, we don't know if we're going to actually get res judicata against all these other plaintiffs. And the court said that's a viable concern of the defendants. We need to make sure that due process is protected in this procedure because of that very concern. And so here we have no notice, we have no opt-out. We have disclaimed that they are adequately representing the interest of these absent beneficiaries.
Counsel, can I ask a question, though, about that? Now, I realize the issue of whether this is really gambling or not is something that will have to be decided not by us, or eventually maybe, but in the first instance by the trial court. But let's just assume that this lawsuit alleges that these are contracts based on a gambling consideration, which by law are void contracts. And I read 8-1-150 as a statute that, yes, it creates a cause of action, but it's really a statute to keep people from gambling. Is that a fair statement?
I would believe that, yes, the 8-1-150 is part of the general Alabama public policy against gambling.
So can the legislature pass a statute like this that basically makes citizens private attorneys general to bring actions and with the purpose of discouraging gambling or, enforcing the public policy that they've determined the state should have, which is anti-gambling, and therefore take it out from under Rule 23, take it out from under some of these other issues, and I guess to put it simply, make it hard for companies or individuals that are engaged in gambling activity, if indeed it turns out to be that, to carry on business here. Is that just something that when you do that, you just have to deal with it?
Well, I would respond to that by the 14th Amendment due process rights. The legislature can't bypass those due process rights
Right.
of the defendants and the plaintiffs. So if the legislature wanted to enact an act that provided for a procedure of this sort and also protected the due process rights of the plaintiffs, I think that would be fine. But we don't have that here. 81150 cannot be read in a way that says that it allows for a class action, which it was written in 1852. A class action didn't exist in 1852 when this was written. There's no possible interpretation where this procedure was written into this because it didn't exist at the time. I see that I'm out of time. I will close by just saying 81150.
Mr. Ashcroft, you're out of time.
Oh, I'm sorry.
Justice McCool, did he answer your question?
Yes, you did. Thank you.
Okay, thank you. Madam Clerk, if you'll add his time too.
Chief Justice Stewart, Justices, may it please the court. I'm Johnny Norris. I represent the plaintiffs in these cases. And I want to begin by going back to Justice McCool's question, which was, does the legislature have the power to do this? And the answer to that is an emphatic yes. In 1905, the United States Supreme Court was faced with an appeal from the state courts in Ohio over a key tam statute based on the statute of Anne that is very similar to the one that Alabama has embodied in 81150. And what the Supreme Court, the U.S. Supreme Court wrote about the Ohio statute was to say that such a statute must be limited to a provision allowing a recovery of the money by the one who lost it would be in effect to hold invalid all legislation providing for proceedings in the nature of key tam actions. Statutes providing for actions by a common informer who himself had no interest whatsoever in the controversy other than that given by the statute have been in existence for hundreds of years in England and in this country since the foundation of our government.
So is it your position that anybody then could bring this suit?
I'm sorry, Justice.
Is it your position then in quoting this case that anybody could bring this suit? You don't have to specifically be harmed or anything like that. You said that, in a qui tam.
That is precisely right, Justice Sellers. I think that the statute says it. I think that the history of these kinds of statutes say it. And which gets us around to the arbitration issue because it's relevant to that as well. They claim that my client stands in the shoes of these gamblers by virtue of some kind of transaction that I'm not really understanding, but that is not the case here. The case here is that my clients are suing not on behalf of these gamblers and not because they've been assigned some right by some operation of a contract like in an executor case. This is a statutory claim. The right that, as Justice McCool pointed out, the right of my clients to bring this case is founded in the Alabama statute.
But the statute says wife, children, and things like that, and you're trying to say anybody could bring this case.
Anybody can bring the case on behalf of the wife, the children, the next of kin. That's exactly right.
So there has to be some connection. It can't truly be just an outside person that's offended by gambling and they could go and then sue because they're offended by that. There's got to be some causal connection between the person that's suing. Is that your position?
I don't think there has to be a causal connection with regard to the particular client.
Well, it says, I'm just telling the statute says it's got to be, some family member. So you've got to at least have some relation. It says wife, children, if no children, next of kin.
But what it says is that anyone
Justice Sellers, can bring the case on behalf of, or for the use of, is what the language says. Anyone, whether they're connected to these gamblers or not, can bring the case for the use of these family members of the gamblers. And the
You've
reason
got to have,
for that,
so you've got to have a connection to the family. You couldn't just be an outside third party. I'm offended by gambling. I'm just going to sue because I think it's a bad thing, and I'm going to use this as my civic duty to stop gambling. There's got to be some connection. You're suing on behalf of this family because they lost money and you want to recover. So doesn't that give you a connection with the actual activity that took place and what would regulate that activity via contract or by statute?
I do not. And I would say that would be the case if for whatever reason the statute or some law allowed the plaintiff to assert claims that would belong to the gambler because of the contract. Because of the contract. It has to be linked to the contract. And in this case,
let me
linked to the, I'm sorry.
I don't mean to interrupt you. Let me start from the bottom and kind of build up. Do you agree with me in subpart A of this statute? It says the alleged gambler can sue to get their money back, right?
That's correct.
So if the gambler was suing here, they would be bound by the arbitration clause. Correct?
I think I would have to concede that point, that if they were suing for their own losses, then I think the gambler who had signed an arbitration agreement would be bound by the arbitration agreement. I think I'd have to concede that.
So let's move to subpart B, which is the part that you're claiming under, right? So it says any other person can sue, may also recover the amount of such money. Did I get that quote right?
Correct.
So such money is the money from subpart A, right?
The losses are the same, but the source of the claim is different. Because in this
but it says may also recover, so may also. So if subpart A didn't work, if the gambler wasn't entitled to the money, then this person suing on behalf of the family is also not going to be entitled to the money because it says also recover.
Justice Cook, I think that the difference there is what is the basis for the claim? And in subpart A, it's the transaction between the gambler and the winner. Subpart B gives any other person the right to bring the claim on behalf not of the gambler, but of the family of the gambler, as Justice McCool pointed out, as a means to deter gambling, because that gambling is
but if
policy.
the gambler couldn't recover under subpart A, except for the statute of limitations. So the gambler couldn't recover under subpart A for some reason, like, for instance, it wasn't really gambling or whatever. Then the person couldn't recover under subpart B either, right?
I would say that the defenses may be similar, Justice Cook. I would say that if the transaction itself was not gambling under Alabama law, then neither subpart of 81150 would apply. I mean, one of the things we do have to prove ultimately in the trial court is that this is gambling that is illegal under Alabama law, which I think we'll easily be able to do that. But the issue when it comes to the arbitration, though, really comes down to the question of whether my clients were parties to the contract. Now, in the Wiggins case, the most recent case, and in the Reedstrom case, those were hard questions that this court faced, and particularly in Wiggins, because in Wiggins you had an arbitration provision that clearly did not apply to the disputed issue. It clearly did not. But in that case, the majority of this court, of which I believe there are 3 justices on the court today from that majority, they decided that because of the delegation clause, that this partner in the physician's practice was bound by it because he was asserting a claim as a third-party beneficiary of the contract. So there is a distinction, I would submit, in this court's arbitration jurisprudence between a non-signatory who otherwise is bringing claims that essentially depend on the contract and someone who is not a party to the arbitration the contract containing the arbitration agreement at all. There is a distinction. I mean, for example, I can't enforce an arbitration agreement that I have with somebody over here on a completely unrelated transaction with somebody over here. Yes, I am party to a contract that contains an arbitration provision, but the question must arise, are my client's claims derivative of that contract? And they are not. As I pointed out at the beginning of my argument, these are statutory claims. And so you don't have to reach the hard question that this court was faced with in the Wiggins versus Warren Averett case. That question was, well, we know that this guy's asserting a third-party beneficiary claim. Just like in Riedstrom, the insured was asserting a claim for, it was basically a coverage question, suing the insurance company for failing to cover a claim under the policy of insurance that person was insured of. Those questions are completely different from the issue of what do we do when somebody's not a party to the contract at all? And my clients, it is undisputed on this record and based on the allegations in the complaint and the admissions of the defendants in this case, are not parties to that contract.
But in the Briarcliff case, that was a wrongful death case. And we did the same thing that we did in the South Trust, which was a contract case. And we said, wrongful death case, the personal representative is suing, but the decedent was bound by arbitration. Therefore, the personal representative is going to be bound by arbitration. Wasn't a contract case. It was a wrongful death case. It was a tort case. Why isn't Briarcliff or South Trust, why don't those mean that you lose? I don't understand. Help me distinguish those two cases for me, please.
Well, I think in both of those two cases, what you had was a person who was acting on behalf of the estate. In other words, it was the estate's claims. And I think that this court itself drew the distinction neatly in the South Trust case itself. When, yes. In the South Trust case, there were two issues. The woman who turned out to be the administratrix of the estate was making claims that were based on the decedent's claims. And for those purposes, this court held that, well, you're standing in the shoes of the decedent. The decedent was bound by an arbitration agreement, so you must be bound as well. But then this court went on to say, with regard to the claims, that this same person was bringing, not on behalf of the estate, but rather on her own behalf, it said, this court has noted arbitration is a matter of contract, and a party cannot be required to submit to arbitration any dispute which he has not agreed so to submit. Although this court has recognized certain situations in which an agreement not to arbitrate may extend to non-signatories, see Oakwood versus Godsey, these limited exceptions are not applicable in this case. First, Melody, who was the name of the administratrix, has not agreed to arbitrate her claims against South Trust. Additionally, if Melody is asserting a tort claim based upon an injury she suffered directly, she is not seeking the benefits of the Edwards South Trust deposit agreement. Thus, she is not a third-party beneficiary of that contract. So I think this court made the distinction, Justice Cook, that you were asking about rather neatly right there. It's in the facts of that case. Issue is, am I standing in the shoes of the party who entered into the arbitration agreement? Bound by arbitration. Am I asserting different claims that are my own claims that are not in any way dependent on the contract? No arbitration.
Mr. Norris, I want to redirect you for a minute. Are the appellees purporting to be private attorneys general here in these actions? Is that what you're saying they are?
You know, Justice Mitchell, I have read much about what is the definition of a private attorney general, and there's a million different ones. I would say that pursuant to the Supreme Court's decision in the Marvin versus Trout case in 1905, there's really more of a relator or an informer, qui tam kind of action. A private, but on the other hand, it could be a private attorney general action depending on how you define that. And I think that, frankly, the courts have been all over the place and it's practically indefinable. I think what you're looking at here is that the state, and there's no question but that the state of Alabama, the legislature, has the power to pass a statute that where the state could recover this money itself on behalf of all of these families and give it to those people. What the state did when it passed this statute instead did what was very traditional in the day, which was to say, well, instead of giving that power to us, we're going to assign the state's power instead to an informer or relator in a key tam question. I'm sorry, in a key tam action. And that's exactly what happened here. And so, since this is an assignment of the right of the state of Alabama to pass a punitive statute like this that would punish people, companies that take money based on gambling, it is an assignment not of these gamblers' rights, but of the state's right. And when you put it like that this is an assignment of the state's rights, the state has exercised these rights on behalf of the families of the gamblers, and it is only the gamblers themselves who are subject to the arbitration agreement. You can see that you are several steps removed from having an enforceable arbitration agreement against my clients, who are complete strangers to the arbitration agreement. They're not standing in the...
One thing I'm trying to figure out is what kind of action we have below. If it's a public law action, the standing's a thing. And I think that kind of gets to some of the questions Justice Sellers was asking you about, do your clients meet the standing requirements? If it's a private law action, standing's not a thing, but there are other requirements. And I'm trying to get you to commit. What's your position as to what we have going on here below? Is it a public law action or is it a private law action?
For purposes of standing, I would say that under the precedents, because I think this court follows the Lujan case on Article 3 justiciability. I mean, it's obviously the constitutional provision in Alabama is not Article 3, but I think that what we have here is the traditional kind of case that was recognized by courts for years and years. And let me cite you two cases. One of them is Vermont Agency of Natural Resources versus United States ex rel. Stevens. That's reported at 529 U.S. 765. And there, Justice Scalia, who, as we all know, was a famous traditionalist when it came to jurisprudence, when they were considering a qui tam kind of statute, we are confirmed in this conclusion by the long tradition of qui tam actions in England and the American colonies. That history is particularly relevant to the constitutional standing inquiry, since, as we have said elsewhere, Article 3's restriction of the judicial power to cases and controversies is properly understood to mean cases and controversies of the sort traditionally amenable to and resolved by the judicial process. And so what that means, Justice Mitchell, is that you don't have to have a particularized harm if you're bringing one of these traditional kinds of cases. And as I argued in the Sixth Circuit Court of Appeals just last week, since these are the kind of cases that have been recognized at common law for literally hundreds of years, you don't have to get to what has been known as a proxy for standing, which is normally a court only addresses if the plaintiff themselves has a particularized injury. In these kinds of cases, though, there is a particularized injury that was suffered by the families of these gamblers. That particularized injury has been assigned by the state of Alabama in its capacity to have brought the claim itself if the state had passed a statute doing so, and is assigned in a very traditional manner, and it is a way to meet Article 3 standing because
is the alleged injury assigned the injury of the folks who allegedly lost money, or is it
it's not the
injury of purported injury of the state?
It's the purported injury of it's the purported claim of the state. I think you have to differentiate between the claim and the injury, because here the direct injury, of course, was suffered by the gambler. I mean, that's the person that suffered the direct injury, and that's redressed by 811-150 A. But the courts have recognized that the state could bring a claim on behalf of the families themselves who were not directly injured. They could bring that claim within the power of the state. And that has been, and it's that right of the states that has been assigned by 81150B. I would also cite to you the case of Sprint Communications Company LP versus APCC Services Inc. That's reported at 554 U.S. 269. That's a 2008 case. In that case, the old payphone operators were suing Sprint, and their claims were extremely small. And so instead of themselves bringing hundreds and hundreds of small claims, instead what they did is they assigned all those claims to an aggregator. This was a private assignment case where there was a contractual assignment. And so the question was, well, since the what they called the aggregators that were bringing the case were not injured themselves, is there Article 3 standing? And what the Sprint court held is that, of course, it said, it is of course true that the aggregators did not originally suffer any injury caused by the long distance carriers. The payphone operators did.
But the assignment in that agreement, you're assigning certain rights to the aggregator. And I think under that, as I understand it, I mean, that assignment assigned those specific rights. So it's not the aggregator was totally independent, but they were basically being assigned these rights and were acting on behalf of the various operators that got nickeled and dimed, if you will.
But that may have been the facts. The decision is rather, I will say, unclear about where the money went and things like that, because the court in the next passage I'm about to read to you directly said it doesn't matter who you're acting for, because this is a qui tam relator kind of case based on an assignment. And so they said the defendant argued that the aggregators lacked standing because they did not stand to participate in the recovery. The recovery is all going to go to these small payphone companies. And the Supreme Court wrote that, well, and if the aggregators prevail in this litigation, the long distance carriers would write a check to the aggregators for the amount owed. What does it matter what the aggregators do with the money afterward? The injuries would be redressed whether the aggregators remit the litigation proceeds to the payphone operators, donate them to charity, or use them to build new corporate headquarters. Moreover, the statements our prior cases made about the need to show redress of the injury are consistent with what numerous authorities have long held in the assignment context, namely, that an assignee for collection may properly bring suit to redress the injury originally suffered.
Mr. Norris, can I steer you back for a second? And Justice Cook touched on this earlier. Why isn't your claim, as far as the arbitration, much more similar to like the wrongful death situation? Because that's purely a creation of statute, the right to bring a wrongful death action in Alabama. And the personal representative has to do it in that case. And so here, as I keep reading, you're under subsection B, right?
Yes, sir.
So it says any other person, that would be presumably your client, within 12 months and so forth, brings the action. It says for the use of the alleged gambler. So ultimately, if you're successful, right, it would be for that person's use, not your client's use.
Justice Mendheim is one step removed. It's not I'm not recovering the money for the use of the gambler.
Mm-hmm.
The statute says I'm recovering the money for the use of the families of the gambler,
Okay.
who themselves are not parties to an arbitration agreement.
Okay.
But
how's that,
case?
as a practical matter, any different than a wrongful death situation that has to go to arbitration? But for the wrongful death statute, there would be no right of action other than a criminal homicide case.
And the legislature has created statutorily a right of the administrator of the estate or the executrix of the will to bring a case on behalf of the decedent. But in that situation,
on behalf of
in that situation,
the decedent's dead, they get nothing.
Sorry, Justice Mendheim.
The decedent is dead, and obviously they get nothing.
They get nothing, but the statute makes the right of the decedent to be the same as the right of the administrator. And that's not the case here, because here, if my gambler was suing, they would be subject to all kinds of different defenses that are not applicable to my clients. My clients aren't standing in the shoes of the gambler. They are simply bringing the state's claim.
But
they're bringing
the
the state's claim to recover on behalf of the family.
Is for the use of the family.
The use of the family.
So,
and these
why wouldn't the arbitration agreement govern then? Our understanding of arbitration.
Say that again.
Under our understanding of arbitration, why wouldn't it govern in that situation? We all agree that you don't necessarily have to sign the contract, an arbitration agreement, to be bound by the arbitration agreement. It depends on the circumstances, right?
It depends on whether you're actually making a claim that relates to the contract, which my clients are not making a contractual claim at all. They're making a claim based on a statute only. And if there was no contract at all, you can have, plenty of people have gambling. You can walk into a casino and sit down at a blackjack table and play, and they don't make you sign an arbitration agreement.
I understand. Okay. All right. Thanks.
Mr. Norris, can I ask you a quick question? I see your time's getting short. As for the arbitration, so this statute says that all contracts founded in whole or in part on gambling consideration are void. Okay. Does that void the contractual provision of arbitration?
Absolutely. Under the Greyhound
So
case.
who determines, I think there's been a lot of talk and argument about who, arbitrating, whether it's gambling or not. Who determines whether it's whether gambling consideration is the basis of the contract? Is that the court, or is that does that have to be determined before you even move into applying the provisions of the contract? I'm sorry, Chief. His time's up. Can you
go ahead and answer, Mr. Norris?
Yeah, I think that that question does have to be answered at some point before the court can reach the question of whether there is a valid contract here under the Greyhound case, because that case clearly shows in that context where this court had repeatedly held and decided that the electronic bingo was illegal gambling under Alabama law. But I think that is a claim that needs to be fleshed out in the trial court before a final decision is made, because obviously the trial court's order suggested, well, this is probably going to turn out to be a completely void contract, so there's no arbitration under the Greyhound case. But the trial court did say, well, there's a little bit more that needs to be fleshed out.
Thank you, Mr. Norris.
This court has had occasion in the gambling context to say that this court looks to the substance rather than the semblance of things to avoid evasions of the law. That principle ought to guide the court's analysis of both issues in this case, because everything that we're hearing from the plaintiffs is basically a suggestion to elevate form over substance, and it is an effort to evade both the Federal Arbitration Act and Rule 23. Nowhere is that clearer, I would suggest, Justice Sellers, than in the response to your question, where you asked the plaintiffs what their position is with respect to whether there needs to be a connection between the plaintiffs in these cases and the family members on whose behalf they purport to be asking. To be clear, plaintiff's answer today was consistent with the position they've always taken, which is that there doesn't have to be any connection whatsoever. That is an intentional tactic by the plaintiffs in an effort to avoid the arbitration provision. That is a tactic that should not work, in part because it just can't be the law. On the one hand, that there doesn't have to be a connection between the plaintiff and the family members on whose behalf they're asserting these claims. We've addressed the history of similar provisions in our briefs, and I'm not going to dwell there during my limited time of rebuttal.
Can anybody then, and is your position that only certain people can sue your client? Can anybody sue your client on behalf of the state? They're against gambling and they want to make a point. Can they just sue you, or do they have to have some connection?
No. Ultimately, Justice Sellers, and frankly, I don't think that this is an issue that is necessarily teed up for the court in this appeal. It's more of a question of standing, but ultimately, any plaintiff that tried to assert one of these claims to help a family member recover would need to show some sort of connection with the family member. They need to explain why the family member couldn't bring an action on their own behalf, or why the player who spent the money on the games couldn't bring an action on their own behalf. But ultimately, the more fundamental point is that the reason why the plaintiffs have disconnected themselves from either the family members or the players is that they want to say that they're not bound by the same arbitration provisions that the players themselves signed up for. That cannot be the law, and that the principles set forth in South Trust versus Ford would prevent that evasion of the law.
I have a question similar to what I asked earlier. So I think there's some real factual issues here that, it's not right for us to be looking at yet, but the question of whether this is indeed a gambling contract founded in whole or in part upon gambling consideration. Okay, number one, if it turns out to be a contract founded in whole or in part upon a gambling consideration, it's sort of a two-part question. Number one, does that void the arbitration provision of that contract? Does it void the entire contract? And number two, does that mean that the trial court has to make a preliminary determination at some point that this is indeed a contract founded in whole or in part on gambling consideration or not?
Let me answer your second question, and then I'll try to answer your first. I'd answer your second question in much the same way I answered Justice Wise's question earlier, in the sense that because we're not in the Macon County Greyhound Park territory where we have a game that is clearly illegal gambling and has been announced to be illegal gambling over and over again, ultimately the question of whether this is gambling and the factual disputes that Mr. Norris referenced need to be decided by the arbitrator, not by the court. But the fact that ultimately the plaintiffs want the arbitrator, or perhaps a court, to say that this is gambling does not mean that the arbitration provision is not to be enforced. That's so in light of the U.S. Supreme Court's decision in Buckeye, applied most recently just this past November by this court in a case called CNU of Alabama versus Cox. In that case, the plaintiff had alleged that she had a loan contract that violated Alabama law. Ultimately, this court said that the question of the voidness of that contract, the validity of that contract, would be decided by the arbitrator under Buckeye. And Justice Stewart wrote then Justice Stewart, now Chief Justice Stewart, wrote a concurrence in that case that said, ultimately, if the arbitrator decides that the contract is void, that may mean there's no more arbitration. But Buckeye holds and CNU confirms that the threshold question, at the threshold, the case needs to be sent to arbitration, and the arbitrator will resolve those issues.
So,
Hang on. Do you want him to answer your first question now?
you don't mind.
Okay, if you'll go ahead and answer the first question.
I thought I was answering the first question with that.
You were, yeah, go ahead. And you've answered it well enough.
Okay. Thank you, Mr. Nyman.
Thank you.
Go ahead. Have a seat. Thank you. Thank you all very much, Mr. Nyman, Mr. Ashcraft, and Mr. Norris. We will be adjourned, and we'll take this under consideration.
All rise. The court is adjourned.